All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Okay, good morning. We're here for oral argument in case number JV 23-0035 in re the termination of parental rights as to JC. Council, we were reminded we are recording and live streaming the argument, so please identify yourselves and who you represent at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel, if you'll watch the clock and reserve as much time as you desire for rebuttal. Also, please keep in mind we have read the briefs, we've studied the record, and have discussed this case in conference. With that, counsel for appellant, you may proceed.
Good morning. I'm Suzanne Sanchez. I'm counsel for the appellant, NC. And before I go further, I see that my clock started automatically. That's good. I'm going to reserve about 5 minutes for rebuttal. And this case is about parenting. And, you know, parenting is so rewarding, and it's also really difficult. And, you know, most parents struggle. And unfortunately, some parents struggle more than others. And when that happens, DCS, the Department of Child Safety, gets involved. When they do that, when DCS gets involved, they have an obligation. It's a constitutional obligation founded in due process to provide family reunification services. That is to make a bona fide, diligent effort to reunify the family, and to do that throughout the reunification period. Here, in this case, DCS fell short of that. The way that they fell short is that they didn't do everything that they should have done to make a diligent effort to help the mother learn to meet her child's special medical needs.
Does the law require them to do everything they could have done? I don't read our cases to require that.
Agreed, Your Honor. That goes back to Mary Ellen C. Not every conceivable service, just services that are not futile. And that, to me, goes to one of the linchpins in this severance order, which is the court said that DCS didn't do everything it could have done for the special medical needs. It didn't give the mother notice of medical appointments. Sounds like a small thing. It's a big thing, because going to medical appointments is where we learn the ever fluid medical condition of ourselves and of our children and other loved ones, and how to best meet those. And
wasn't the original basis for the dependency mother's admitted failure at that time to understand the child's special medical needs? Wasn't that the driver of the initial dependency?
Yes, Your Honor. In fact, it was the driver at the beginning and the reason that DCS got involved. And it was the driver, or the main obstacle to family reunification all along. It was the number one thing that the mother...
But it was also her marijuana use. That was clearly stated early on. And also her mental health issues. Both of those were part of it too.
Yes, she did use medical marijuana, and that was something that she struggled with at the beginning, although she did cease her use at the end. And so the way that she used
3 weeks before, with no treatment and no testing.
She didn't engage in the treatment and testing that was offered to her as well as she should have. And those things, the fact that this young first-time mother didn't engage in services as well as she should have at the beginning, is essentially the reason.
You say at the beginning, she didn't engage in them really, at best up until the very end. And even then, it wasn't a lot.
Sure. And for the sake of argument, let's say we have a parent who struggles the entire time to engage in services, which would be different from this. But for the sake of argument, let's say that. That's not a basis for a futility finding. And remember, here the court...
I have 2 questions, and then I want to get to futility. One, is your argument that the state needed to comply with 8846 and Rule 340 to not give mother notice? It seems that's what's in the brief.
Yes, that would be the ideal way to do it. Under 8846D and Rule 340, DCS should file a motion. The mother can and would ask for a hearing, and then the aggravating factors would be examined at a hearing. Now, Christina...
Was that required here? Was it a failure to not bring that?
I would argue yes. And at first blush, Christina G., cited by DCS, seems to say differently. What it says there is we don't need a pretrial determination so long as DCS doesn't halt services altogether and still offers some services. But I would say here, where the place where DCS fell down is with the number one obstacle to reunification all along, the special medical needs. If they don't do that, they may as well stop offering services altogether. It's a functional equivalent. And I would say the logic of Christina G. implies that if you're going to stop completely or do the functional equivalent of it, have a hearing. But say I'm wrong and you can skip that hearing. We still didn't have a statutory aggravating factor here. The court said it was futile because the parent struggled with the other services that she was provided. That's not a futility factor. And I don't think that's a nitpicky little technicality here. I think that excusing DCS from its constitutional obligation to provide services before it overcomes any parent-child relationship can be excused only if there's legal futility. And that's just 6 things under the statute.
So would it be different if they hadn't offered substance abuse, had given her notice of all the appointments, but not the substance abuse? What was the second thing that they raised, the medical marijuana?
If I understand your question correctly, I would say it wouldn't be any different, because if you never teach her how to meet her child's special medical needs, family reunification is never possible. So any reunification.
So how then is her failure to do anything about and it was a diagnosis of a marijuana abuse, right? It wasn't just that she was using medical marijuana or using it often. She was diagnosed as having a condition where she was abusing marijuana. Am I right on that?
Mild, it said, yes.
But she had that.
Yes.
And her own testimony said she was using it 3 times a day, every day, 6 grams a day, starting in October, right before she was even terminated. So there was a lot of use. If she couldn't meet that, if you're saying, yes, if they hadn't provided that service, then that would be grounds to not terminate. But why if they provided the service and she didn't meet it? And I'm going to disregard the mental health because the Superior Court didn't make a finding on mental health in one section of the order. But if she wasn't able to meet the marijuana, why wouldn't that stand independently, just as it would stand independently on the futility piece?
One reason is she wasn't severed on a substance abuse ground, but another reason is you just have to, not you, but DCS just has to address the special medical needs. And if the question is if her marijuana use made her unable to learn that would have to be one of the futility factors. That would have to shoehorn into.
Well, they said her medical abuse caused her to not be able to parent. In fact, at the end, she acknowledged that her medical or her marijuana use affected her ability to parent. She acknowledged that.
At the beginning, when she was 18 or 19 years old, it did. She had just had a child, and it was impacting her ability to learn to meet those special medical needs right away. And I think we'd want to encourage her to be honest about that and to agree, right now, I can't take care of my child. Please help me learn to do better.
So what I want to understand with futility is how, because we don't hold the parents or the state to a standard of perfection.
Right.
So futility seems to be the answer to that issue, which is the state's going to make a mistake, a parent's going to make a mistake. And certainly for parents, the argument is, look, they can still do it. They missed this one piece, but everything else is there. And you make that argument. For the state, they said, we missed a piece, but it wouldn't have made a difference. It almost seems to me it's a harmless error. That's what futility is. It was wrong. And I'm not going to suggest that I think the state did a good job with that piece of it. They failed to give mother notice. They were ordered to. But at what point, what's the consequence for that?
The consequence is it's not legally futile unless it meets one of the aggravating factors under ARS 846. The parent can't be found. Then you don't have to give him services. The parent says he doesn't want to reunify. then you don't have to give him services. The parent is so mentally ill or so intellectually disabled that evidence establishes that it's impossible for them to benefit from services. Don't have to do it there. If DCS has taken this child twice before and tried unification and it doesn't work out, then it's legally an exercise in futility to try a third time. Or if the child is convicted of a crime against children, then we don't have to attempt.
So any service that they overlook somehow would preclude, unless it falls into the 846D list.
Yes. Yeah,
Okay.
legally, the state has an obligation. It's a big deal.
Well, and I'm not going to disagree, they have the obligation. My question is, when they fail to meet the obligation, what is the consequence? And I look at 846A, and 846A, which is where 846D comes from and flows from, is except as provided in subsections D, E, and F of this section. If the child has been removed from the home, the court shall order the department to make reasonable efforts to provide services to the child and the child's parent. Here, I don't think there's a dispute that the court did it. So 846A was complied with. The problem is the department didn't follow that order. So what is the consequences of failure to follow that order?
If they fail to follow that order and the court does not find it futile, then they haven't made a diligent effort. And a diligent effort to reunify the family is an element of both of our termination grounds here.
And futility has to be based, from your perspective, on 846D.
Yes.
8834, I'm sorry, I said the number wrong, but
Absolutely. I mean, this is a big deal. It's the fundamental constitutional right to parent your child. Before the government can interfere with and terminate that, it needs an adequate justification. And an adequate justification, this is substantive due process that I'm talking here, an adequate justification in this context is a bona fide, diligent reunification effort. And futility
could
is
it ever be harmless error?
no.
Could it ever, so it could never be, and harmless error and futile, do you agree that harmless error and futile are essentially the same thing, that that's what we're really looking at when we say it would have been futile, it wouldn't have made a difference? And maybe fundamental error would be a better, but.
I think it is comparable to harmless error in the criminal context. If I understand
Right.
what you're saying is, okay, they didn't do what they were supposed to do, but it doesn't alter the outcome. And I would say, I'm going to stick to my argument, and this is an example. This is neglect for not fully understanding her child's special medical needs, which she owned up to, and the 15.
What about the 15 months in care,
Yeah.
though? Her
No.
reasonably likely to address the problems.
Sure.
This is where I think the challenge is, because is it reasonably likely, as the judge sat there, that she was going to address the marijuana abuse problem under those circumstances? And if she couldn't address that, doesn't that support the 15 months? Tell me why not.
Because one of the primary circumstances, in fact, the main one, was the special medical care. Some parents' use of medicine, whether it's Benadryl or medical marijuana or Xanax, if they manage it correctly and have a safety plan, they still can learn to meet their child's special medical
But
needs.
in the almost 20 some months that this was in place, I think the girl was 26 months old, but the dependency didn't start until she was 9 months. So in that whole time, mother didn't have a safety plan for the marijuana. Mother didn't have control of it. She, in fact, up to at least the December first day of the trial, mother was pretty much out of control with it.
And the whole thing flailed around, and the department wasn't stepping up on giving the mother reasonable notice of what was going on with her child.
But how does that relate to the marijuana? Because she had to do two things here. And the state argued she had to do two things. She had to learn about the kid, and she had to get the marijuana abuse under control. They also said the mental health. Again, I want to set that aside. So she had to do two things.
Yes.
They messed up on one, but mother never did anything about the second.
Yeah, and I think she was young. Imagine having one's child taken away and being out of the loop on grave medical concerns.
So was it an abuse of discretion for the Superior Court to find that it was likely that mother was not going to be able to resolve it anytime soon? Just the marijuana abuse piece. Was that an abuse of discretion?
It was, because we can't truly measure that unless DCS steps up and offers all the services the whole time.
How does the service, because how does the service regarding the daughter's appointments, and again, no excuse from my perspective for not having done that, but how does that relate to the substance abuse problem?
I think from a real world basis, people use more medicine and more marijuana and struggle more in their lives when they're in a state of downward spiraling despair, when someone's taken their child away from them and they were on board with it because they thought they were going to be properly taught how to take good care of her, and that doesn't happen. I can't.
And if I could just get one in here. You had this discussion where you basically sounded like you were arguing that, any failure to provide an ordered service creates a constitutional problem. And I think that for your position, you don't need to go that far in this case, do you? I mean, isn't your point, and you've been very clear about this, that the special medical needs is a special category of service that is primary to this dependency and termination. And so it might not be that in every single case of failure to perform an ordered service, parade of horribles, we have to reverse every termination. But I think your point is that this one is special, and that factor in this case is extra special.
Yes, it goes to the heart of what we were talking about a moment ago, which was the primary obstacle to reunification all along. So I absolutely, I mean, and I think that goes with Christina G. If they're just going to drop off a couple services and still make an effort, that could be different. But when they're going to drop off what's the primary star service and not offer that, and there's no chance of reunification, they can't do that. They have.
So on the futility piece, was it an abuse of discretion when the judge looked at everything and said, look, she wasn't going to a lot of her other appointments, she wasn't compliant with other things, to use that as evidence to suggest that she probably wouldn't have gone to the medical appointments too? And I want to keep in mind that she wasn't going to appointments that she could have had all day to do. She didn't test, but she was too busy for it.
I still think it goes to the futility factors. In Christina G., the court cites the futility factors that applied there and highlighted the evidence that met them. So that even when we determine futility later in the severance order, which I don't agree with, but for the sake of argument, it always has to tie to legal futility. Yes. I did reserve the rest of my time. Thank you.
Thank you.
May it please the court, my name is Dawn Williams and I represent the Department of Child Safety. And I think it's clear that this court doesn't need to reach the constitutional issues that Mother has raised because there's more than sufficient evidence to support the juvenile court's reasonable efforts finding.
Was there a constitutional requirement to provide services in this case?
I don't believe there is, not a constitutional requirement. No.
After Jesse D., you don't think so?
I don't think so, and here's why. Jesse D. refers back to Mary Ellen C., which then in itself refers back to Santosky. And this is essentially a house of cards that's been built up since Mary Ellen C., and courts have been citing back to Mary Ellen C., saying, here's why services are constitutionally required, because Santosky says so. And Santosky says no such thing.
Okay, let me pause you, please, counsel.
Sure.
In Jesse D., paragraph 18, Justice Bean, I think, for unanimous court, said that while B4 does not impose an explicit duty to provide reunification, the absence of a statutory duty does not obviate the state's obligation to provide the services. And he cites Mary Ellen C. for the following. Arizona courts have previously recognized a requirement to engage in reunification efforts on constitutional grounds as a necessary element of any state attempt to overcome the fundamental liberty interest, which occurred here. What takes you outside that language in paragraph 18 of Jesse D., counsel?
Sure. First of all, I think the court was incorrect in saying that the court has previously found that there's a constitutional requirement for every ground.
But when the Arizona Supreme Court says that that's what courts have found, that makes it the law, whether Mary Ellen C. was wrong to say that or not, Justice Bean adopted in Jesse D., no?
And I think this court can read that as dicta, because that portion of the opinion is addressing the court's departure from prior case law in James H., where this court had said reunification services are not required for length of incarceration termination because there's nothing that services can do to remedy that length of incarceration.
Sure, they would have essentially been futile, one could say.
Exactly.
Exactly. And the court found that notwithstanding that, they were constitutionally required. And in paragraph 21, which is the operative holding of Jesse D., Justice Bean wrote, "We are mindful that requiring DCS to provide reunification services to that incarcerated parent is a departure from prior Arizona law, although it is a constitutional requirement under Santosky." Does that not mean that the Arizona Supreme Court is acknowledging that prior case law or statutory law violated the federal constitutional rights of parents? Yes or no, please, first.
I'm sorry, can you repeat that?
Sure. Justice Bean wrote in the operative holding, paragraph 21, "We are mindful that requiring DCS to provide reunification services to an incarcerated parent is a departure from prior Arizona law, although it is a constitutional requirement under Santosky." Is our Supreme Court not instructing us as a court, and you as your client as an agency, that prior case law or statutory law violated the federal due process rights of Arizona parents? Just yes or no before you answer further.
Yes.
Okay, thank you. If you'd like to continue as well.
In the context of the length of incarceration termination ground.
Counsel, let me jump in. Do we need to consider this issue? Or if the court decided to affirm on and find no abuse of discretion on the futility of finding and affirm on the 15-month time in care, then why would we need to discuss Jesse D? Or because I think we all know, or I don't think there's any objection of anybody in the room, that services are required clearly for 15 months time in care. Is that your position?
Exactly.
Do we need to go outside?
No, this court doesn't need to reach that issue at all, because what the juvenile court found here, both today in argument and in the briefs, Mother has repeatedly said that the juvenile court found that DCS failed in its obligation to instruct her about her child's medical needs, and that's simply not true.
Okay, but the court also found that the department never advised Mother of the child's medical appointments. We've discussed the centrality of the child's medical needs to the dependency and termination. You understand that that was an important service in the context of this case, right?
Absolutely. But
okay, and then the court further found Mother at hearings and foster care review board meetings regularly requested to be advised of medical appointments so that she could participate in those appointments and understand the child's medical needs better. That's a finding as well, right?
It is, yes.
Okay, so we have to defer to the finding that the mother was seeking to go to those appointments and consistently asking to for the purpose of learning about the child's medical needs. So why is that when it's requested by the mother, just like in James H. it was requested by the parent, why isn't that a constitutional right that the mother had to have those services? Why isn't that therefore included within the definition of reasonable services under 846A, counsel?
Two things, if I may. First, the juvenile court also found that DCS had made multiple efforts to advise Mother of the child's medical needs by providing her with all of the child's medical records and regular reports that were offered to the court that detailed all of the child's needs and the services she was receiving to meet them. And Mother, by her own admission, did not review any of that information and was not familiar with the child's medical needs. So it's not the fact that DCS didn't provide her with that information. It's the fact that she didn't avail herself of it. What DCS didn't do is didn't itself provide her with notice of the child's medical appointments. If you look at ARS 846B, the legislature has said if DCS can offer services through another means, it doesn't have to offer them directly. And here, DCS relied on the foster parents and the prospective relative parents who were setting and attending those appointments to keep Mother apprised.
And wouldn't it have been easier just to give her notice of the appointment so you don't have to rely on an after-case ruling that it was unlikely she would have gone when she consistently asked to go for good reasons?
Well, the record demonstrates that DCS did provide her with that notice up until the caseworker who had taken over the case a month before the trial.
Well, actually, I think under Brianna J., when the court finds the department never advised Mother of the child's medical appointments, that pretty much stands as a factual finding that we all have to deal with, right?
And assuming we take that as it is.
It's a finding.
Sure.
It's on page 6 of Judge Brooks' order.
Sure.
So with that finding being such as it is, once again, so you're basically, it's sort of like U.S. versus Leon. There's like sort of an inevitable discovery. She should have learned by reading medical records, but we don't force parents in general American society to read the medical records when the doctor's sitting right there. So why is that reasonable? That doesn't sound like the word reasonable to me, counsel.
Well, there are several issues here. Normally, when a parent has a child with medical issues, that parent is directly responsible for that child's care. Here, the child is in DCS's custody, but DCS doesn't make those appointments. It relies on the foster parents to do so, and it did so here. So if we were going to require that information to go through DCS, then the foster parent makes the appointment. They call DCS calls the parent. It injects delay that if the appointment especially is an emergent one, could result in having to postpone the appointment until the parent gets notice. That's not a workable or an efficient way of handling this.
But the court didn't find that the failure was excused. The court basically just said, well, mother wouldn't have participated anyway. The court didn't say what you just said. And in fact, I understand my colleagues' questions to be likewise. None of us seem to be excusing this. So one of the things that the state's brief said that was interesting is at page 27, it basically says, well, if she had been given notice, she would have not gone to those, just like she didn't go to any other appointments. The word any is used categorically. Isn't it true that Judge Brooks found that, and I think the language in the brief was, as with all the other service appointments, she just did not bother to attend them. But didn't Judge Brooks find at page 11 that mother had not substantially neglected or willfully refused to participate in services? And don't we have to live with that finding too under Brianna J?
I agree. And the idea is that the mother did minimally participate in some services.
So the statement she didn't participate in any is not a correct statement. It's perhaps an exaggeration or hyperbolic to a certain extent.
Exactly.
Okay.
And the issue is that the medical appointments she did attend, she was playing on her phone rather than attending to what the doctor was trying to relay regarding the child's medical history. So I think it was absolutely within the juvenile court's discretion to find that advising her of every single appointment would have been futile because there was no evidence that the appointments she did attend had brought her any closer to understanding her child's medical needs.
So federal due process is interesting because you don't have to create rights to procedures in state law, but sometimes when you create them, they can create federal due process rights. And counsel has consistently argued for the mother, using Santosky and Jesse D over and over again, to invoke rights of federal due process. That was most of the context of counsel's argument. So whereas here we have a statute that gives the state many opportunities to seek to withdraw important services by motion, doesn't it affect a further due process violation to decide it at the end of the proceeding with no prior notice on motion? Can you speak to that, counsel?
Sure. I think the problem here is that mother has conflated the aggravating circumstances of ARS 8846 with the futility finding, which is a creature of case law. So nothing in ARS 8846 addresses futility. There can be a finding that those services could completely help this parent remedy their deficits. And yet, if one of those circumstances is proved, DCS doesn't have to provide those services.
One of the circumstances in D, you're saying?
Yes, exactly.
Okay.
One of the aggravating circumstances.
Mhm.
Whereas the futility argument comes directly from the definition of reasonable services. It's not reasonable to provide a futile service. And that's something that the juvenile court, who's heard all the evidence, is uniquely in a position to determine here.
Right, exactly. Exactly. We're on the same page because I don't see futility in this statute anywhere, and I've read all the cases just like you. But when I look at this, what's interesting is the idea that reasonable services don't include something where reasonable services are defined in A to be you always have to do it except if D is present. So I'm troubled by the idea that we have something that's not in the statute that's an additional condition, and worse than that, it doesn't obey the conventional rules of these exemptions. The state has exemptions in D, but they require clear and convincing evidence, correct?
Yes,
They require a motion on notice to counsel, correct?
correct.
None of that happened here with this futility finding because it was at the end of the case, right?
That's correct.
So that's procedurally
Yeah.
a much more powerful tool for the state, isn't it, in terms of the counterweight it provides to the parent's substantive due process rights, doesn't it?
I don't think so. And I would point out that the court did make its findings here by clear and convincing evidence. So I think that
Where does the state find futility by clear and convincing evidence? I would like to be referred to that.
it's just the court made its termination order by clear and convincing evidence. It found the ground for termination, including the 15-month ground, which has the diligent efforts requirement.
But it found that the mother, quote, was unlikely to have participated. That's its first reason on page 6 that it was irrelevant that the state did not offer this information to mother because it was unlikely she would have participated. The court did not find by clear and convincing evidence that she would not, correct?
Not explicitly, no.
Unlikely sounds like more likely than not, right? That's my last question on this
Okay,
point,
go
sorry.
ahead.
Unlikely means more likely than not. Unlikely is not by clear and convincing evidence as to that one finding, right?
As to that discrete finding.
Yeah, sorry.
Let me ask you, when a standard has been identified by the courts, don't we presume that the court knows of that?
Absolutely.
And does the court, have we ever, in any case that you're aware of, required the court to expressly say, I find by clear and convincing evidence, or we will somehow presume or assume the court didn't make that finding by that standard?
Not that I've seen.
And so when we, under this case, presume that the court found by clear and convincing evidence, it was unlikely mother would have. Unlikely isn't an evidentiary standard. Unlikely is based on the statute that says mother, it has to be reasonably likely mother's going to cure the problem, especially under the 15 months time in care. Isn't that accurate?
I would agree.
Okay.
And the other issue here is that ARS 8846 is a statute in the dependency process. It is not a prerequisite for a termination of parental rights. The legislature and our courts have never required a finding under ARS 8846 in any direction before terminating parental rights. And I think Christina G. made it very clear that the court said, if DCS is going to say all reunification efforts are futile, yes, it should go before the court prior to doing so. And as you said, provide notice to the other party, get a hearing, get a formal order. But when, as here, DCS doesn't provide a single service, then the court is absolutely within its authority to say that single service was futile, and it doesn't negate the overwhelming number of services that DCS did provide.
Well, let's look in that bucket so we don't analytically flatten all 9 of them into equality. One of the services that Judge Brooks indicated correctly was offered was transportation, correct?
Correct.
Okay. Which is more important in the context of this? Offering you a ride to a counseling appointment or being apprised of the child's medical appointments? Does the state recognize that the one is more important than the other or not?
No, because I think if DCS had provided her notice of that appointment and she had no way of getting there, it would have been just as much an error as if DCS had not provided her notice.
Okay. In the context of this dependency, is there any service that is less important than going to the child's medical appointments, or are they, in the state's view, all exactly equal in importance?
I don't know that we can parse that. I think that's up to the juvenile court to say, here's the totality of the issues that mother was facing and the services that were provided to meet those. Did it rise to the level of a diligent or reasonable effort? And the court here found that it did.
Well, it's our job to parse that too. And so in terms of a reasonable or diligent effort, I'm asking you whether the state's position, I clearly understood counsel's answer to this to be that some services are created more equal than others, like an animal farm, and that this case is really about the alleged medical deficiency of information on mother's part. Mother's consistently asking to go. Judge Brooks was troubled by it, obviously. The court has considered whether the department's failure to provide this notice rendered their efforts less than diligent. So it troubled Judge Brooks. I appreciate that he was troubled. I'm troubled by that, obviously. So is it really the department's position that all these services are sort of exactly equal in importance, or is this one more core than others?
Well, DCS will often advise a parent, why don't you focus on this issue first? This is your biggest issue. And for this mother, one of the biggest issues DCS wanted her to address was her significant marijuana use, because that was impacting her ability to understand her doctors or to stay awake during visits or to participate in her mental health services. So DCS can absolutely and does prioritize services over the course of a dependency. The fact of the matter here is that it didn't matter what DCS attempted to prioritize here. Mother simply didn't participate until the time between the first and second days of trial.
Well, and DCS's position in his brief is that she didn't attend any appointments, but that's directly contrary, as we elicited, to Judge Brooks' finding at page 11.
Can we talk for a moment about the futility versus, as I had suggested, that it's really, to me, seems to be analogous to a harmless or fundamental error. Let me ask you this. Do you agree DCS, under these circumstances, should have provided or given mother notice?
I think based on the court order that had been entered that DCS do so, yes.
And that's part of the challenge. We have a court order. I understand your reference to subsection B, but B isn't where DCS can hide because it had a direct order to do it. So it was a failure on DCS's part. When DCS fails to provide, and in this case, because I'm focused on the 15 months in care, when DCS fails to provide one service as part of its diligent effort to provide the appropriate reunification services. So not a deny all. I think you've made that point that 846D has historically been used for the no services position. When they make a mistake, what is the consequence for DCS? Because is it contempt? I mean, is that what the court could have done? Or does, is it that the court has to, at that point, then continue the dependency until DCS complies? Or is it a discretion of the court?
I think it's a discretionary finding. I think when the court finds, as here, that ultimately it would have made no difference, then the court can go ahead and terminate parental rights. If the court had said, as mother argued, that DCS failed to provide this mother with any information about her child's medical needs, the court very well could have denied the motion to terminate her parental rights.
Actually, under these circumstances, the court could have denied the motion because of failure to give notice. Would that be fair? It would not have been
Sure.
abuse of discretion?
If the court had done that, that would have been well within the court's discretion to do.
Isn't that the challenge we have right now? We're really dealing with a case where two people could look at it and say, don't terminate, make DCS give mom more time and give her notice of the appointments and let's really see what happens. Or we're going to terminate because the court found, and presumptively by clear and convincing evidence, it's unlikely mother would have gone.
And that's what really this comes down to, is that was a discretionary finding, and that was a finding that the juvenile court was entitled to make, but that juvenile court decision is entitled to deference. And so given that the juvenile court did weigh all of the evidence and determine that this single service would not have been dispositive, this court can affirm the termination order based on the court's finding regarding the myriad other services that were provided that mother simply didn't avail herself of.
So the purpose of 846 is to provide services to the child and family. That's what the statute is called, right? Services provided to the child and family, correct?
Correct.
Okay, that's the purpose. So to the point of your last answer, counsel, ARS 1-211, Rules of Constructions and Definitions, tells us as judges, and also Judge Brooks as a judge, how to interpret 846. And we agree that the object of the statute is to provide services to child and family. I'll quote 211. Statutes shall be liberally construed to effect their objects, here apparently the provision of services to child and family, and to promote justice. Doesn't that constrain Judge Brooks, and doesn't that constrain us today in terms of construing 846 and whether services should be provided or not?
No, because DCS did provide services here, and Judge Brooks found so.
I'm sorry, as a matter of statutory interpretation, was Judge Brooks bound by 211B's injunction that statutes shall be liberally construed to effect their objects and to promote justice?
And I believe he did.
Okay, and so you agree that that controls what he does and what we must do in construing 846?
In construing 846, yes.
Okay, and so to effect its object of providing services, it's nonetheless in furtherance from DCS's point of view to affect the object of that statute to have this relatively core service, very core service, as counsel has argued, not provided. That promotes justice and affects the object of Section 846A.
Again, DCS disputes that finding, but DCS wasn't aggrieved by the order and couldn't challenge it.
Right. And at the end of the day, it really isn't about punishing DCS or what's good or bad for DCS, because this is about family and then ultimately the best interest of the child as well, correct?
Correct. And we have a child with significant medical needs and a mother who has not even the beginning of an understanding of how to meet them.
And before the termination, the mother's and the child's interests are aligned in that they both have an interest in the receipt of services, barring a finding of danger or something like that, right?
Barring a finding under ARS 846.
Yeah, no such finding was made. Nothing further from me.
See, I'm out of time. Thank you.
Thank you, counsel.
Thank you, counsel.
Going to the mother's progress with services near the bottom of page 11 of the severance order, it says her more recent engagement outweighs her prior failure to participate. And I think especially in light of her young age and being a first-time parent, that's important. And we talked a bit also about what's the remedy when DCS doesn't offer a service that it should have done. I think that the remedy ought to be decided before we get to the severance trial. I believe that that's the point of Rule 340 and 8846. If they want to either stop offering services or its functional equivalent, then they ought to file a motion and get a ruling.
Well, how would they reasonably know that? That's a dependency statute. That's in the dependence. That's part of the dependency. You're expecting them to look in the crystal ball, perhaps, and see, we're just going to, isn't it in a way that counterproductive and cut off the right to a parent to a reasonable opportunity by cutting it off too early? I don't know how that you make that decision.
I understand that there's some difference between dependency and severance, but in a state case, many of them, like this one, the child is found dependent. That's the mechanism for the child to order the parties to attempt family reunification and then add issue in the severance. Almost always, unless it's an abandonment case, is how did that reunification attempt go? What progress did the parent make? And what services, what diligent efforts did DCS make? That's usually the main star issue at any severance.
But if DCS determines, we're not going to do that, that's not what we want to do. We want to see if we can provide reunification. That's the goal. And yet, why couldn't they continue to go down that path? And then yet, still do what's reasonable. Isn't that what we're really, we're fighting over the word reasonable a lot here. I think back and forth. I mean, we're not fighting, we're discussing, we're trying to figure out what does it mean to provide reasonable services?
I would submit the problems with that here. Let's use this case as an example. They didn't offer something that was pivotal to addressing what was the main obstacle to reunification all along.
Did anybody say that was the main obstacle? Like at testimony, or, because I didn't find that.
I don't recall somebody making that express statement, but the record speaks for itself. DCS got involved because of the special medical needs, and that's what makes this child different from other children and harder to parent. I don't think we'd be here if my client had had a child with the typical physical health that most babies have.
But you wouldn't dispute that a lot of the cases we see have the child have special needs.
More than just this one, but the majority of them don't. The majority of children have, I mean, there isn't the perfectly healthy child or the perfectly anything child, but I would submit that the majority of the children that we see do not have special medical needs to this extent.
Well, maybe not to this extent, I agree.
Quick follow-up, and I just want to focus. First, are you saying that every time DCS stops a service, they should file a motion? Because there are a lot of referrals that get closed. Substance abuse referrals get closed even for a parent who's facing a substance abuse termination. Are you saying every time that happens, a closure, they should file a motion with the court?
No, I'm saying that
How do they decide when?
When they're going to stop making a diligent effort or do the functional equivalent. If they're going to stop offering all services, Christina G., or if they're going to do the functional equivalent, that if they're going.
So if it's a substance abuse grounds, your argument is you can't close the Teros referral because that's the key service, even if the parent isn't going.
Unless you're going to get a court order or offer the parent a different substance abuse service. But I think this is different because DCS didn't offer mother a service for this. They argue here today that it's too cumbersome to give her appointment notice because it's the foster mother or the doctor's office who scheduled these. I mean, we've got.
I think they conceded it was error. They violated the court order, essentially. I think you have that concession. So,
counsel, your time is up. We thank you both for your arguments this morning. Very helpful discussion. The court is going to take this matter under advisement and will issue a decision in due course. We'll now stand adjourned.